With that being said, we will now move on to agenda item number 9. We'll have the opportunity to continue our discussion regarding the implementation of AB469 from the 2017 session related to the reorganization of the Clark County School District. As we heard in public comment, there's still work to be done, and so I had asked our Deputy Attorney General David Gardner to please provide us with a short and sweet overview of legislation so that we could be very clear about the law and where we stand and what our role is in it. And then I also asked Deputy Superintendent Felicia Gonzalez to provide us, and I think everyone's received this now, with the dates based on the law, like what is required by when. And so I'm going to turn it over now to Deputy Attorney David Gardner to give us that overview of the legislation and the legal actions that have come through related to the bill and contextualize any future actions we may take. There were some that we discussed in that previous meeting that I think we need to now determine what we're going to do next. So, Mr. Gardner, please proceed when you're ready.
Thank you very much. My name is Deputy Attorney General David Gardner. First off, if you go to the next slide, please. I want to go over the history just so we kind of are all on the same page. I know some of you have been involved this entire time, so you know this, but it's always good to kind of go back. This bill was originally created in 2015 session, the 78th session, and it wasn't a complete bill. The bill was created to create a group called the Advisory Committee that was going to decide a plan on how to reorganize the Clark County School District. They were going to be aided in this by a technical advisory committee, which included most of the local governments, CCSD, State Board of Education, local businesses, etc., and all trying to implement this plan. So basically, they both hold meetings. I think we had 18 plus meetings between the two of them, where we'd go out into the public or have people come to the meetings and provide input. And then eventually, the advisory committee approved a plan to reorganize the Clark County School District in August of 2016. That was then passed to the State Board of Ed, which approved of it on September 1st, and then it was approved by the Legislative Commission on September 9th. After that, Clark County sued to overturn the plan. That lawsuit was stayed shortly thereafter because they agreed to it with the defendants. If you can move to the next slide, please. And the reason why it was stayed is because AB469 was being debated. AB469 took the regulations, the plan that was created by this advisory committee, and instead of keeping it in regulation, they put the entire thing in the statute. So during the 2017 session, or the 79th session, the Nevada legislature debated and eventually approved AB469. The Assembly voted 40-2 in favor, and the Senate voted 21-0 in favor, and it was signed by the governor on May 8th. After that was passed, CCSD stipulated to dismiss their lawsuit because their lawsuit was a technical lawsuit, saying that there were certain technical things that the previous legislation did not do, and so when it had been passed, it kind of destroyed that argument. And then in 2018, the Department of Education entered into a joint implementation plan with CCSD to ensure the implementation of AB 469. This was done by previous Superintendent Canavero. And one of those things, which is something that has been discussed here quite a lot, is that the plan requires CCSD to make sure that their employee contracts executed after the authorization of AB 469 complied with the following criteria. 1, the principals have the authority to select all staff for their schools. And 2, that no portion of any employment agreement for their employee unions allowed for placement of an employee into a school under the supervision of a principal without the principal having selected that employee. If you go to the next slide, this is where we get into actually the legalities, the legal history of AB 469. The first bite at the legal apple was the Attorney General's opinion requested by the former superintendent. This was done on February 15th, 2018. The question was specifically whether a large school district could assign a teacher to a local school precinct without its consent. So without the consent of the local school precinct's principal. And the answer that came from that was that Nevada law does not allow a district to assign a teacher to a local school precinct without the consent of the local school, or without the consent of the local school precinct. And any provision in the collective bargaining agreement executed after the effective date of AB 469, which was in May of 18, I believe, what was it? I think it was May of 18. Yeah, May of 17, sorry. Any collective bargaining agreement after that date, which would waive or modify a local school precinct's authority to select their teachers, would be unenforceable against the precinct. The AG's opinion is still the current opinion of the Attorney General. These are not lightly taken. They take a lot of steps, but that is still the current opinion. But it is advisory. It is not binding on the courts. It can't, just because the AG's opinion is out there, does not mean a court has to follow it. It is just based on what the Attorney General's decided it was. Wonderful, you're already on the next one. The next legality or legal issue over this bill was the EMRB order. So on December 7th of 2020, declaratory order was issued by the Government Employee Management Relations Board. The question was somewhat similar, but not entirely. It was whether NRS 288, 1502 sub 2 sub U allows CCSD to assign an employee in a school without the school's consent in light of NRS 388G 610. So more or less it's the same thing, but this is being seen through the lens of collective bargaining. That's the NRS 288. The context I put in there because the EMRB stated, as they know and as anybody who deals with these, you only have the jurisdiction which the legislature has given you. And so their jurisdiction, they said they do not have jurisdiction to see if this violated NRS 388G, or if it's a breach of contract collective bargaining agreement, or determine if NRS 388G 610 impacted the parties' negotiated agreements. That was outside their purview, and so they couldn't get involved with that, and that was just a jurisdictional thing. But they did come up with an answer, and their answer was that they think that 288, NRS 288 and NRS 388G can be read in harmony, which means that one doesn't win over the other. And because of that, they said that you would have to negotiate the rights that are in 388G 610. So that selection had to be negotiated. So it didn't really answer whether it could be placed or not. It just said that that had to be bargained between the bargaining units. And if you go to the next one, please. This case has actually been updated. I didn't catch it because I thought the case had kind of been finished after the last hearing, but I decided for fun to look up the docket today and all the new filings, and there's been action in it. So basically, the last 2 points are kind of gone, and I'll explain why. Basically, the Principals Association, which is titled Clark County Association of School Administrators and Professional Technical Employees, asked the court to prohibit CCSD from placing teachers or staff in their local school precincts, citing to this NRS 388G. The court dismissed the writ of prohibition because it said that it was an extraordinary remedy, meaning that it's not a normal thing. You have to hit a really high standard for the court to grant it. And it said they didn't hit that standard. But then it had these two bottom bullets which said, oh, well, they found that the local school precincts were given the authority to select their staff. They must select the staff from a list provided by the superintendent. And then they said that the court found that the authority to select staff by the local school precincts is only that authority possessed by the superintendent of CCSD at the time it was transferred, which is similar in reasoning to the EMRB ruling. But what recently happened, which is what I was looking at today, is there was a motion to amend the previous order, basically asking the judge to look at it again, saying, hey, we think there's some problems in here, because typically, if you're going to dismiss a case on a procedural issue, which is what this one was dismissed over, you don't get into the merits, which means you don't decide rights and things like that. So when I read the first order, I kind of thought the same thing. So that they filed this motion. Funny enough, the motion was denied, but in the order denying the motion to change the previous order, it states, the court's earlier decision was not one on the merits, but only found that the extraordinary remedy of writ relief was not warranted. Basically making those two bottom points just dicta, which means that it's not binding. It's just something the court said, but you couldn't enforce it in a future case. That was just something that was said, and the only thing that this case actually happened was they had hit a very high, it's because of extraordinary remedy, and they didn't hit it, and that's all the court said. And those are the basically the three cases that have been out on this bill. Basically, where we're at right now is where we were at the beginning, because this lawsuit has basically hasn't really given us anything one way or the other. The EMRB ruling is very narrow, and the AG's opinion is advisory. So we don't have a lot of clarity because none of these things have provided it. The legislature or court deciding on the merits can provide us clarity, but as far as right now, we don't have it. And then the next slide, please. We wanted to talk about, this is something that was requested, to discuss service level agreements, seeing as those have been talked about in the public comments quite a bit. So service level agreements are outlined in 38G 610 subsection 7, which gives the authority to carry out responsibilities listed in the subsection 3, besides capital projects, if it is determined that transferring the authority will serve the best interest of the pupils. So what does that mean? Service level agreements are if the district has provided responsibilities down to the local school precinct, the local school precinct can hire the district to do those services for it, but they need an agreement, and that's the service level agreement. The money for that comes from the money to pay for that is found in 38G 660, 1 sub E sub 2, which talks about that 85% of the total amount of money from all sources received by the large school district that is unrestricted for the school year must be transferred down to the local school precincts. And then this board already, you decided to add a little bit of clarity to what allocated means. And so in NAC 38G 140, this board put into regulation that stated, money shall be deemed allocated to a local school precinct pursuant to 38G 660, the one I just read, only when money is included in the portion of budget for the local school precinct over which the local school precinct has control and discretion with respect to the manner in which the money is used. So if you've limited it that allocation of 85% can only count if the local school precinct has control and discretion. And so there is a definition, and I point that out because that is the power of this board. It's something we've talked about previously. What can you do? You have the power to define a lot of these ambiguities. So if you see something, you're like, well, we kind of disagree with how this is being done, or we disagree with how that term is being defined, this board in regulation has the authority to define it and clarify what it actually means. Okay, back to service level agreements. So basically, service level agreements, school district, local school precinct decide they want to work together. The local school precinct decide they want to hire central or the school district to do it. The requirements of the service level agreements, as I was saying, were decided by this body. You guys in 2018 decided to put these into regulation, which means that if you want to change them, you can. If you want to add to them, you can. If you want to make less of them, you can. This is well within your purview. Next slide, please. This is just an overview of what a service level agreement has to have. I put it all in there because I think it's important, and I apologize because it's going to be quite a mouthful, but these are things that service level must include that this body put into regulation. It must have the purpose of the responsibility. It must have the legal requirements applicable to the responsibility. The requirements that the local school precinct must follow. A description of the scope of the responsibilities, including how the quality of services will be evaluated, and what the local school precinct can do if it's not satisfied with how the school district performs. Those things must be in it by Nevada law. So when we're looking at service level agreements, those are things that are supposed to be there. But the service level agreements aren't created in a vacuum. In fact, the requirement, once again in statute, is before finalizing a draft of the service level agreement, principals are allowed to comment. So they're allowed to comment before it's finalized. So the associate superintendent is supposed to bring the draft, their pre-draft service level agreement to the principals and say, this is what we got, what are your comments? The associate superintendents are then supposed to take those comments back to the superintendent, who can accept them, reject them, whatever, but he's supposed to take them into account and then finalize the service level agreements. After that, around on before January 15th, the school district must publish and make available to the principals of each precinct drafts of each local service level agreement. So the superintendent finalizes and then must provide these to every principal. But then this is where the principals get the second bite at the apple. Under the laws, once again, this board created, the principals can negotiate the specific terms of the service level agreement. It can't be just given to them as a, here you go. The principals have the authority under the regulations to negotiate. What that negotiation will end up, I don't know, but they have the right to negotiate it on that as well. Another, sorry, I skipped my second point. Another thing that the service level agreements must have is it must include the amount of money the school district will charge to carry out the responsibility. And then it can't give this school district power over the principals, and it can't give supervisory power, and it can't give the school principals supervisory power over central. So, and that's once again defined in regulation by this body. So, and the next slide is just questions. So I know I added a lot and they're all kind of off from each other, but these were kind of the issues that kept popping up in public comment. And so those are the ones I focused on. If you have other questions, I'm happy to answer any of those, and I will do my very best to get you the answers for those if I don't have them.
So, okay, I will open it up to the board for questions or comments at this time. I think that helps personally, I'm speaking personally here, to add a lot of clarity for me, especially around the SLAs and where we're at with the current litigation that has taken place. So I'm going to open it up to the rest of the board for questions and comments. And then Deputy Superintendent Gonzalez, I want to prep you. I want to circle back to the few things that we mentioned in the previous meeting that we were going to consider adding clarity to. The one thing that I remember clearly was in good standing. We wanted to add some clear definition to that, but there was a couple other things. Anyone else remembers them? Help me out.
Greatest extent possible.
Thank you.
I didn't hear the second one, I'm sorry.
Was
Extent possible.
Okay.
sorry.
It can support.
Okay, so I'll open it up for questions or comments at this point, and then we'll dig into those other conversations. Anyone? Yes, Member Dockweiler.
I'll start. Member Dockweiler. Two-part question. First one is, are the current SLAs, do they have all the requirements that are outlined there, and are the processes being followed?
I unfortunately don't have the SLAs in front of me.
One moment.
Yeah.
Thanks for the logic.
I was enjoying watching deputies.
Okay, let's pivot it.
So, this is Deputy Attorney General David Gardner. I have not seen the SLAs, to be honest. I don't have them right here in front of me, so I can't verify whether they comply or not. As well as the procedures, that is something that CCSD is required to do, and I think it'd be a question better for them or from their principals to see if that is actually happening. I don't know either way. I apologize.
Okay. No, thank you. I realize you actually probably aren't the right person to be asking that. But the second part, then maybe I don't know. We'll see. Since part of the options in that agreement is to negotiate, is there also an option to reject? Or is that something that the board is within the power to modify that?
Well, the board is in their power to modify that, because once again, this is all in the regulations which you guys established. So these are your regs, you can play with them however you like. As far as whether they have the right to reject it, part of an SLA is you have to get both the local school precinct and the school district to both want the deal. If the local school precinct doesn't want the deal, then they don't have to hire the school district.
But, if that service is legally required to be delivered to students, like say, social worker, or I'm trying to think of because of IEPs or, like transportation, that's like, I think federally required, right? Like, we can't, a local school precinct couldn't reject the SLA because then they wouldn't obviously get the money for it, which would, then the school district would be violating the law, but they also wouldn't be fulfilling their legal obligation to students, right?
This is Deputy Attorney General Gabe Gardner. There would be the requirements for like federal and stuff like that would have to be complied with. In this case, if you look at NRS 38G 610 sub 3, it has about 20 different things, and those are the things that the school district can transfer to the local school precinct, because an SLA can't happen until the power has been transferred to the local school precinct. And it's my understanding that I'm not sure any of these have been transferred.
Okay.
And so there would be no SLAs, because until the school district votes the school board votes to transfer that power, there wouldn't be an SLA for that.
So that's the rub right there, is that the school district hasn't voted to transfer, and I'm gonna turn it over to Superintendent Ebert to maybe give us a little clarity.
Yeah, thank you. So as so Superintendent Ebert for the record, so as the team has been digging in, and then also with the help of principals and others of what has transpired during this time, our understanding is that since 2017, or in 2017, custodial services and technology supports were transferred to SOTs. There have, as far as we can tell, there haven't been any approved SLAs since 2017. So that's kind of, beyond that. And I know Deputy Gonzalez also too has worked with others to find out additional information. If you'd like us to share that.
Yes, please.
Thank you, Felicia Gonzalez, Deputy Superintendent. For the record, so in 2018, Clark County School District did do a group of items that were technically transferred to the school district. So, and these were things like transportation and landscaping, etc. They were transferred, but not where they provided them the authority to provide these services for themselves. It was part of their way of meeting that 85%, meaning they could see on the budget that these things, even like the costs of utilities and et cetera, are on their screen in their budgets, but they don't have control. They don't have control and discretion over them. And then so they are provided a monetary amount, and they see these items, but then the district does take those monies and then pull them back in as in they have paid for their services at the end of the school year.
And they have not relinquished control or discretion of those dollars to the schools.
Felicia Gonzalez, for the record, they have not relinquished any individual discretion or control to any one school precinct.
Okay.
That we know of.
So I received a letter from the CCSD superintendent stating that they will comply with providing SLAs by 2022. But that means that they've been in not in compliance for the last 3 years. And that means that, so is it within our authority to request a copy of the procedure and drafts of those SLAs prior to the January 15th deadline to show that they're making a good faith effort to negotiate with SOTs?
So
with precincts?
Felicia Gonzalez, for the record, you may request, but unless it is in regulation and Deputy Attorney General Gardner did just explain that unless it is written in regulation, you cannot require them. So you can request, and if they don't agree to that, then that may be something that you can move to a regulation.
Or we could just do regulation right away. Essentially, yes.
Deputy Attorney General David Gardner, you also have, the superintendent also has some powers to get information under NRS 388G 580. And because some of this, like for example, would fit, in my opinion, under D3 sub D, which is detailed information regarding other budgetary items of the large school district. Some of that may fall into SLAs. There's a couple of these categories SLAs may fall into. It may not, but I think that I would lean towards they probably do fall on this. So it may be within the superintendent's ability to ask. Once again, we get into the situation of what happens if they don't, and there's no punishment written into the law.
Okay, so I have a thought, and I'm just going to put this out there for us to discuss. What if, specifically when it comes, and I'm focusing on SLAs right now. We can talk about the employment stuff next if we need to, but can we request from the district a outline of the procedure they're following for developing the SLAs with all of the criteria that was outlined in our regulation from 2018, class, responsibility, who's, how we're measuring quality, et cetera, right? What is that procedure? How it, at what point are they then turning those drafts over to the school precincts so that they have enough time to actually give feedback, draft the final, give feedback again to hit the January deadline? Can we make that ask? And then and give a deadline? Mm-hmm. Please provide this information in the next 30 days kind of thing. I'm not saying that that's what you have to put in there. I'm just giving you an example. That way we can judge their responsiveness. And if we don't get good responsiveness, then our next step would be to set new regulation that says by, say, October 15th of the previous year, we must have a list of the SLAs in draft, not only a list of the SLAs they're proposing, drafts of them, and for our review, obviously we're not going to do anything with them, but just review that they check all the boxes of the things we're asking for. And then that the procedure is being properly followed, that they're presenting those drafts to the precincts for review and feedback negotiation technically. Because what I'm concerned about, let me wrap this up in a bow. What I'm concerned about is if there's two things. Number one, if the precinct doesn't get them in time to have negotiations so that they can then budget properly, because budgeting starts in January, then that's kind of skirting the responsibility. And then two, if they're not actually giving the school precincts control and discretion, they're not hitting that 85%, which puts them in violation of the law there as well. Any thoughts on that? Go ahead, Member Dockweiler.
Member Dockweiler, I definitely like the direction that you're going with this, because and again, I don't know how to solve this, but this might be the way to do that, is about the appearance of the transfer of autonomy and funds, but they don't actually have the autonomy and funds. So if that is the way we can achieve fixing that, that would be great.
Yeah. And then I think we may need to consider, secondarily to all of this, is if they don't comply and like January 15th rolls around and they haven't done, the proper SLAs that actually give control and discretion to the schools, precincts, do we need to add regulation to have some sort of ramifications? Or is that just like you're breaking, I don't know. I'm at that point I get a little fuzzy.
This is Deputy Attorney General David Gardner. Those type of regulations would be in the authority of this body. As long as it's not violating the statute, the Constitution, or other specific statutes, you have quite a wide latitude. So if you wanted to create something where that would help enforce the law, I don't know exactly what you could do off the top of my head, but you would be able to look into that, yes.
Okay. Okay. I just want to, so I'm just speaking here personally, I want to see that there's a good faith effort being put in place to, A, follow the law, but B, do so with integrity in having that feedback loop for negotiation and final approval, and that the control and discretion is truly transferred. Is everyone in agreement on that path forward? So the action then, just to button in, the action then would be for the superintendent to issue a request to the district to show us the procedure that they're now following to get to that, so that they would be in compliance by January 15th, meaning they would have to, in very short order, have those SLAs drafted and presented to the districts or to the precincts so that they could start giving them feedback. So, and I'm especially,
This is member Cantu.
yes, member Cantu.
Yes. My thought is I would agree with what you're saying in terms of making a request and providing a deadline, but my concern is, having a sense of urgency that the schools that have talked to us, rural schools and others, who do not have any level of control when it makes more sense for them to have control over some of these SLAs, continue to have to operate under these, kind of unfair rules where there is a semblance of autonomy, but in terms of, spirit, it is not adhering to the law. I guess I have a sense of urgency in terms of, helping those schools and districts have more local control over their SLAs. And I wonder, if, what we could do in terms of regulation should the letter not work, to help, compel the district to come into compliance with the letter and spirit of AB 469.
So, okay, that's a great point. And I think that we can request the SLAs for the stuff that has been identified as already being transferred, custodial technology, utilities, transportation, for example. And then